Quorum is present. Some housekeeping matters to dispense with first. The Committee on House Administration has approved a process for the electronic submission and posting of public comments for each item on today's agenda. The public comments submitted through the portal will be posted on the Electronic Legislative Information Systems, TLIS and TLO, as well as on the House website at the conclusion of today's hearing. Directions of how to submit public comments on the portal can be found on the meeting notice for this hearing. Today, we are scheduled to hear invited testimony only on the following topic: criminal procedure related to capital punishment and new science writs under Article 11.073 of the Code of Criminal Procedure. Before we get there, I wanted to open the floor here to the members of the committee if they have any comments to make before we start today's here. I have some that I would like to make before we take testimony, but I wanted to invite my colleagues as well. So, yeah. Okay. All right. Well, then I will go first, and then I think some of my colleagues may have some words to say. My expectation was that we would have Robert Roberson here to speak with us, but that won't be happening today. And I'm sure you've all seen the motion filed by the Attorney General's office. And I'll tell you right now that it's filled with dishonest and factually disprovable claims about the process that we have engaged in. Everything this committee has done, it's done in the light of day. We've made every effort to work with TDCJ and OAG, even at the same time as the OAG telling us as members of the legislature we have no right to speak to a state agency. All that communication, all those emails are all public record. If you want them, happy to show them to you. We offered to accommodate them in numerous ways, including back in October. And I can read directly. October 21st, we'd consider it satisfaction of our subpoena and any subsequent one we might be required to issue in terms of timing, if no later than this Sunday our committee was permitted to meet in person with Robert at his place of incarceration or other TDCJ approved premises. The meeting would need to be audio and video recorded. We would anticipate our committee, 2 committee staff members, and Robert's attorney needing to be present with Robert along with any TDCJ staff that is required. I'm happy to discuss any further logistical details with you if we can agree to that in principle. Never responded to. Never responded to. October 25th. I hope you are well. I am following up on the below email from Monday morning. We are earnestly trying to reach an accommodation that would satisfy our needs as a committee as well as address the concerns your office has raised regarding safety. When we spoke Monday, you let me know that you would have to run this by TDCJ and that you would get back to me. Do you have an update to that end? If it is not acceptable to have the entire committee, I am very happy to create a subcommittee of 4 members to come to the witness for purposes of taking his testimony at a mutually agreeable time. We would like to resolve this matter as efficiently as possible, given the urgency of the matter before the court. I would respectfully request a reply by the close of business today. Thank you. The only thing I got back was this response. The subpoena issued to Mr. Roberson required his testimony on Monday, and TDCJ did not impede Mr. Roberson's compliance with subpoena, going so far as to attempt to facilitate his appearance via Zoom, a method used by 2 other witnesses at the hearing. In statements made in our communications and by the House during the hearing, the House confirmed it had no intention of taking Mr. Roberson's testimony on Monday. The House's subpoena is now expired, and the committee has adjourned. The communication she talks about that we never expected to have his testimony that day is they had made it very clear that they would only provide his testimony that day via Zoom. In taking that taking into consideration Robert's attorney's objections to that and whether that accommodation was permissible or something that would be helpful to this committee, yes, we knew that day we were not going to get there. And the question was, how do we come together and figure out a mutually agreeable way, a time, a place? That was the conversation that we started that day. And it was a conversation, as I read to you, I earnestly tried to offer everything I could think of. Never once responded to. But now, in this motion, filed yesterday, here's what the Attorney General's office said. The committee has refused to meaningfully engage with TDCJ in good faith discussion to explore any potential compromise. This is the dishonesty that I'm referring to, because these are just facts. These are emails and public record. This is what they filed in Polk County. This is a lie. We have been attempting to try to find an accommodation since October, and they have never responded to anything meaningfully because they don't want to have Robert here. And it's very clear. The purpose of this filing, you can tell what it is. It's crystal clear because they're asking for a hearing on January 13th. They've clearly shown what they intend to do, which is to run out the clock so that the public and this legislature can't hear from Robert. As much as this is an issue about the authority and dignity of the legislature, Robert is at the core of all this as well. The effort here has been by some to hide him and silence him because his testimony would be instructive, because it would be helpful. Something that really struck me in the AG's filing was their line about bringing him to the seat of our state government. Here's a fact. It's his state government. Just as much as it is ours, just as much as anybody's in Texas. Our laws have affected him as deeply as they can affect anyone. And it's our job here in this building to make sure they're fair and just and work as intended. That job is far from over on this issue, and we don't intend to leave it undone. What you'll hear today is that there are nationwide problems in cases like this. And I know I speak for every member of this committee when I say that we're committed to getting this right and seeing that justice is done. Thank you, members. Anybody have any comments? Yes, Chairman Leach.
Thank you, Chairman Moody. Well said. Appreciate your able leadership of our committee over the past session and during the interim, especially over the past few months as we've dealt with this case and the unprecedented issues that have been in front of our committee and the unprecedented actions that we have together taken. I want to just very briefly speak to my House colleagues, not only who are here present on our committee dais today, but those who might be tuned in and those who otherwise are paying attention and who care about the integrity and the independence of the Texas House and the Texas legislature. I want to speak to colleagues that agree with the stance that our committee has taken, the unprecedented actions that our committee has taken over the past couple months on this case, and those that strongly disagree on this case. I'm speaking to both groups right now. I believe very strongly that all of us should be shocked and alarmed and very concerned with what's happening right now in this case and between this committee and the Office of the Attorney General. What the Attorney General filed last night was, as shocking as it was not unexpected. I actually was concerned and predicted that this exact thing would happen. The Attorney General has told this committee, the chairman of this committee, the members of this committee, that we cannot communicate with an agency under our jurisdiction, that we are barred from doing so. They have made the subpoena that we have legally issued as a committee that we voted on and that we have constitutionally and procedurally done correctly. They have made it impossible for anyone to comply with. They have, the Attorney General last night has, I believe, knowingly and intentionally delayed resolution of the issues in front of us until he knows that those issues will be moot because a new legislative session will convene on January 14th. He just happens to be out of the country until January 13th and has asked for the court in which he has filed his motion for protective order in to not take this matter up until January 13th at the earliest. We all see this for what it is, and as I said, as shocking as it is and alarming as it is, it's not surprising. The Attorney General has never, to my knowledge, appeared personally and argued a case on behalf of the Attorney General's office. He has plentiful lawyers who can and regularly do that for him. And this, if they believe strongly that this committee has not complied with any rules or with the holding of the Supreme Court from last month, then they can, and they have alleged those arguments in the court, and we could respond, and we could have a hearing next week, the week after, certainly before January 14th, when this committee loses its jurisdiction and its power. Members, can you imagine the Attorney General's office telling the Appropriations Committee that the Appropriations Committee cannot communicate with the Comptroller's office? Can you imagine the Attorney General's office taking the position that the Agricultural Committee cannot communicate with the Department of Agriculture, with the Ag Commissioner? Can you imagine the Attorney General's office telling the Judiciary Committee that we cannot communicate with the Chief Justice or with the State Bar? That's what's happening here. That's exactly what is happening here. The Attorney General telling a standing committee of the Texas House that we cannot communicate with the Texas Department of Criminal Justice. And so, members, I know on this committee are concerned. I've heard from members over the last 24 hours since the Attorney General filed his last-minute filing who disagree with us on this case, but who are equally concerned about what the Attorney General has done here. And the Supreme Court, in closing, the Supreme Court, since we last met, members, I know you've all read the Supreme Court's holding in this case. I believe strongly the Supreme Court got it 100% correct. The intent of this committee, certainly my intent, just speaking for me, was never to usurp or overstep the governor's constitutional duties when it comes to carrying out a death sentence, when it comes to granting reprieve or pardon. We didn't ever intend to step on his authority to do so, and don't now. We didn't ever intend to step on the Board of the Pardons and Paroles constitutional authority to grant reprieves, to grant clemency. The timeline that we were under a couple months ago, leading up to Mr. Roberson's original execution date, forced us to do what we did when we did it. And I have no regrets, none whatsoever. Mr. Roberson is still alive today because of the actions of this committee. And the Supreme Court, in its holding, got everything 100% correct, including, most importantly, their directive that the executive agencies, the executive branch, should and is expected to work with the legislature to help us achieve our core functions. And right now, because of the Office of the Attorney General, we are prevented from doing so. Mr. Chairman, I want to thank you again for your able leadership, for your steady hand and your bold leadership. And members of this committee, I have been so grateful to be locked in arms with you in this important cause. And I don't, as I've said publicly many times, I don't intend to relent at all until truth and justice are secured for Mr. Roberson. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. No. Mr. Harrison.
Thank you, Mr. Chairman, and thank you for everybody who's taking the time out of the holiday season to be here today for such an incredibly important and consequential matter. There is nothing more important in this committee, which is a committee of the legislative branch in the state of Texas, and I'll be really clear at the top. It is the legislative branch in the state of Texas that writes the laws in this state. It is only the legislative branch that writes the laws in this state, and it is the legislative branch in this state that gets to determine whether our laws are being faithfully adhered to or not. And this is especially true, perhaps no more important for it to be true, in issues like this, where matters of life and death quite literally hang on that determination. One sad reality that has become and is becoming increasingly clear through this unfortunate and wholly unnecessary saga is that some elected officials actually care about protecting separation of powers in this state, while others, I hate to say it, simply pretend to care when another branch does something that they do not like. I am extraordinarily concerned about the potential precedent that is being set by the actions over the past few hours, in that it appears that at any time the executive branch does not somebody want to testify or to comply with a valid and lawfully issued legislative subpoena, they can simply assert that somebody is on vacation. Think about that. Think about the implications of that. Not just for this case, but for future cases. This is the type of action, I believe, that genuinely gives rise to a potential constitutional crisis regarding separation of powers. And I just have to ask, what do some officials fear? Why do some officials fear Mr. Roberson's testimony so badly? If the case against him is so open and shut as they say, why are they working so hard to flaunt laws passed by our legislature and signed by our governor that should have given this individual a new trial years ago? What is the possible harm in letting him speak here, or more to the point, letting a jury decide his case with the totality of evidence before them, something that has never happened in over 20 years, or at all? Are government officials really willing to let a potentially innocent person be put to death by the government in order to protect the reputation of a government system? As a constitutional officer of the state, as all my colleagues are constitutional officers of the state here, that is not something I will abide by. I will never blindly trust the government. And I will say this to my colleagues on my side of the aisle, it is a wholly inconsistent application of skepticism of government action, which, by the way, all of us who call ourselves conservatives claim to believe, to turn a blind eye to potential miscarriages of justice in our criminal justice or our judicial systems. Why are we skeptical of government action in every other area of government policy except for our criminal justice system? That's a question that colleagues on my side of the aisle need to grapple with. Ladies and gentlemen, we must never stop fighting to protect individual liberty, due process, separation of powers, and, as our founders were so concerned because they spent a disproportionate amount of time in our Bill of Rights protecting the rights of the accused. Texas should lead the nation in just about everything. I firmly believe that. I think everybody in this room probably believes that. But executing innocent people, not one of them. And I don't know who still needs to hear this. But executing potentially innocent people is the exact opposite of justice. And I will be damned if I'm going to sit idly by and let my children, and your grandchildren inherit a state where potentially innocent life can be taken from them by the government absent fair trials and absent due process. We are Texas, ladies and gentlemen, and we are better than that. One thing that needs to be cleared up. While this committee, my bipartisan colleagues on this committee, remain united, the divisions of this case, which have been grossly misrepresented in the press, are not between Republicans and Democrats. They are not between supporters of the death penalty like myself or opponents of the death penalty. The reality is the division in this case is between those people who have studied the facts and who know the facts of this case versus those who do not. And I firmly pray, and I do believe it will become apparent in time, who has been on the right side of history in this case, and who continues to champion the execution of a potentially innocent person who has never had a fair trial. And in closing, I just want to once again reiterate my profound and heartfelt appreciation for every member of this committee who have put aside the issues that usually divide us so that we can come together and unify in the pursuit of justice. Thank you for being here. Thank you, Chair.
Thank you, Mr. Harrison. Okay. Anybody else have any other comments before we begin? This time the chair calls Josh Burns. Mr. Burns, welcome.
Thank you.
To the Capitol. Welcome to the committee. Before I turn it over to you, I want to thank you for taking the time. I know you traveled a little bit last minute to be here with us, but I think it's important that we hear your story, and I want to turn it over to you to be able to do that. Before I do that, let me just do a little housekeeping. I have you registered as Josh Burns, representing yourself, and you are testifying neutrally today since there's no legislation before us. Is that correct?
That's correct.
Okay. Mr. Burns, I will turn it over to you. I know some of the members may have some questions they may ask as you testify, unless you'd prefer us to wait till afterwards, whatever is easiest on you.
If it pleases the committee, I have a brief statement to read, and I'd be happy to take any questions
Sure.
from any of you.
Okay, let's do that. Yeah, go ahead. Yes, sir.
Great. Well, first off, I want to thank the committee today for this opportunity to speak. Again, my name is Josh Burns. On November 21st of this year, I was exonerated of a crime that I didn't commit in the state of Michigan after a 10-year battle to fight for my innocence. 10 years ago, I was accused of shaking my infant daughter, Naomi. She fell ill 2 months into her as a baby, and she had a failure to thrive and was just really struggling to regain her birth weight. So 2 months in, she fell ill, and after 3 days of visits to the emergency room and the pediatricians, she went unresponsive in my wife's arms, and we were in an ambulance going to the University of Michigan Hospital in Ann Arbor. At the hospital, they suspected a virus, and after 10 days, my daughter started to make a recovery. But then everything changed. They found, through testing, subdural hematomas and retinal hemorrhages. And my wife and I found ourselves face to face with a child abuse pediatrician who then called Child Protective Services and accused us of shaken baby syndrome. So over the course of 7 months, my daughter was taken from our custody, put in foster care with strangers that we didn't know. My wife got 3 one-hour visits a week with our daughter, and I was not allowed to see her. Since I was the last one alone with my daughter when she fell ill, I was charged criminally with child abuse. We first had a civil trial where CPS in the state of Michigan tried to terminate both my wife and I's parental rights. After the civil trial, my wife was able to get our daughter home, and I was given 1 hour to pack all my belongings and move out of our family home because I was facing a criminal trial. During the criminal trial, I watched in horror as the prosecutor was allowed to keep from the jury new scientific research, peer-reviewed medical articles that have challenged the legitimacy of shaken baby syndrome. I was convicted and sentenced to 1 year in jail with 2 years probation. Thankfully, the University of Michigan Innocence Clinic took my case on direct appeal, and they have fought tirelessly for the last 10 years for my innocence. Meanwhile, my family and I moved to Texas. Our belief was that Texas cherishes liberty, parental rights, and evidence-based science. But then I learned about Robert Roberson, a father on Texas death row who came minutes from being executed on the same scientifically unsound shaken baby hypothesis that caused my family so much harm. So I am here to speak for Robert today, whose life hangs in the balance over junk science and the shaken baby hypothesis. My understanding is that he did not have the kind of resources and privileges I had. He was from a poor family, had a 9th grade education, and was a special education student with a developmental disability that wasn't identified until 2018. By contrast, before I was falsely accused, I was supporting my family as an airline pilot. Now I work for a Dallas-based airline training pilots. But I almost lost my 25-year career due to this conviction. Another reason I'm compelled to speak out on Robert's behalf today is my daughter, who's now 10 years old, Naomi, is autistic. Learning about this developmental disability through her allows me to see how easy it would be to misjudge someone like Robert, whose way of showing and interpreting emotions is not neurotypical. Although my daughter, unlike Robert, is high functioning, I can only imagine how challenging it must be for him to communicate what it feels like to be caught up in this kind of nightmare for over 20 years. As things stand today, we have more questions and much evidence to support that Mr. Roberson's execution should be stopped. And we must explore the science-based evidence that is calling his conviction into question. I still believe that the great state of Texas is a beacon of liberty. I think Texas has a reputation of being tough on crime, and I think that is good. But we must be smart on crime. And what that means, being smart on crime, means we follow science-based evidence wherever it leads, even if it means we are wrong, especially if it means we are wrong. To play fast and loose with a man's life is despicable behavior, and I'm speaking directly to the Attorney General when I say that. It goes against everything Texas and this nation stands for. I have followed so many cases around this nation. I am the 36th exoneree from shaken baby syndrome, but there's hundreds more. Hundreds of parents and caregivers who are sitting in prison right now, convicted under this false junk science. As an airline pilot, I live in a world where I'm evaluated every 6 months in state-of-the-art simulators. It's called a jeopardy event, meaning that my job's on the line every 6 months. If I don't perform with a mastery of airmanship and in my aircraft, I could lose my job. Robert Robertson's also in the life and death business today, isn't he? And I wonder if our court system and our prosecutors understand the life and death business they're in and understand the gravity of the power they yield in their hand. As we are all anxious to go home this weekend to our families and celebrate the holidays, there's a man sitting in a small concrete cell, waiting for a new date of execution. I want us to all think about that. I challenge everyone in this chamber today to think about that man as we're home with our families this holiday season. Let's think about the reasonable doubt and all the evidence, at the very least, that should lead to a pause of execution and lead to seeking the truth wherever it leads. Thank you.
Mr. Burns, thank you very much. I do have a few questions I want to follow up with
You
you
bet.
on, and I know some of my colleagues might as well. You mentioned that the Innocence Project there in Michigan took on your case,
That's correct.
and they went through the appellate process?
It did.
Okay, and were any of those appeals successful?
None of them.
So what unlocked the door to your freedom? Actually, well, you served your time, right? You served the whole year
I served my whole year and 2 years probation.
and had to comply with all the terms.
I did.
You're in prison. You're in prison. I know a lot of people will say, "Oh, well, it was a 10-year maximum sentence for that crime. He got off pretty light." Tell me about 1 year in prison.
It was terrible. It was a horrible experience. I can't even describe the feeling of going to prison an innocent man and knowing that you're innocent. It is the epitome of persecution at the hands of your government. And it has opened my eyes to the wickedness in this world and the power that can be yielded in the wrong ways.
So how did you ultimately come out from under your conviction? Who
Yeah.
helped you?
Sure. So the Michigan Innocence Clinic, the Attorney General's office in the state of Michigan a few years ago opened up what was called a conviction integrity unit.
So the top prosecutor in the state of Michigan had a conviction integrity unit,
Yes.
and they took a look at your case.
They took a look at my case it took 3 years.
Mm-hmm.
They really took a long, hard look. I had 9 expert witnesses, leading neurologists, leading retinal, pediatric retinal eye doctors that have reviewed my daughter's case. They said none of this is from shaken baby syndrome. This is from a traumatic birth. And there's no science behind how long it takes retinal hemorrhages and subdural hematomas to leave an infant's body. So there was enough reasonable doubt there to overturn my conviction.
So the Attorney General's office led, along with the Innocence Project of
Correct.
Michigan,
They led the fight.
led the fight to make sure that justice was carried out in your case.
Yes.
You know, I know, when I served my time as a prosecutor, that's part of the oath you take to see that justice is done. I'm glad that the Attorney General in Michigan saw that that was their duty as well, to make sure that, to ensure that justice is ferreted out, and if there's a mistake, to rectify it. So I'm grateful for that. Was there anything in the process that looks like junk science relief? You've read about the stuff in Robert's case, and
I have.
this Article 11073 is what we're trying to kind of dig into. And just, is there anything analogous to that, or what are some of the, and I know you're not a lawyer, but as you went through that process, was there some relief that looked like kind of what we have here in Texas, or anything to that?
There's no junk science bill or anything on the books in Michigan in that way. There are many pathologists, doctors who are still brave enough to testify against the shaken baby industrial complex. That's what I'll call it. Anyone who comes up against this group is threatened. Their legal licenses come under. I mean, this is it's a cabal.
Mm-hmm. Well, I appreciate that you took the time to be here and tell us that story, because I think it's important to understand what this looks like.
Yes.
So someone who's been through the entirety of it and proclaimed your innocence the entire time, is my understanding, correct?
Yes.
Any time in that process that you felt beaten down and just wanted to give up and just say you did something you didn't do?
Absolutely. You know, it was, my wife was approached early on in the case, and they said, testify against your husband and divorce him and we'll give you the baby. Wickedness. I've been married to my wife for 18 years. We're a Christian family, God-fearing family. And we weren't willing to compromise the truth. I was given plea deals that I wouldn't take for a misdemeanor. 3 months in jail, I wouldn't take it. But yeah, there were many times where I felt like giving up. And I can't even imagine someone like Robert, with the lack of resources he had, having to go into that fight. I had several expert witnesses. I had a $300,000 legal bill at the end of this to get my daughter home. I came up with $50,000 of it out of my 401k. Church family members, and complete strangers paid the rest. We owe nothing. Robert didn't get that.
Thank you for sharing that. Members, do you have any questions? I'll go down the list here. Questions? Yes, Mr. Harrison.
Thank you, Mr. Burns, for being here, taking time out of your schedule around the holiday time to be here. I think in addition to saying thank you, even though I don't speak for anybody in the government of Michigan, I feel compelled to say I'm sorry that you and your family endured that. It's not right, and it's not just. But if I heard your testimony correctly, it sounds like you are representing that this injustice has befallen many people, not just in Michigan, not just in Texas. How many people do you think might be sitting in similar situations to ones like you sat in?
Hundreds.
Hundreds. Hundreds of people may be sitting in a cage, like an animal, for a crime they did not commit. Is that your testimony today?
Yes.
How confident are you in that?
I'm very confident in that. I have access to many innocent groups, listservs, National Registry of Exonerees, and then people that are still fighting for their innocence. So I can confidently tell you hundreds.
And I know this is a painful topic for me to ask you a couple questions along the lines where I'd like to go, having heard your testimony, just scribbling down a couple notes here. I know it's tough, but I don't think you wouldn't be here if you didn't think this was important. And a lot of people get confused in this case. They see headlines and allegations and just awful sounding words, legal jargon. And can we just bring this back home for a minute and just, we're all human beings, and you're a human being, and your wife, your daughter. Tell us a little about the impact on you and your wife's emotions upon learning about you had a child that had illnesses. That must have been very difficult. Talk about how just the baseline level of struggles you and your family were undergoing, and then layer on top of that what it was like. Take us inside behind your eyes when you learned that not only were you struggling with an infirm daughter at the time, but that you were going to be accused by your government of being the cause of it. What was that like for you?
I felt completely betrayed.
Betrayed by who?
By the system, by medical doctors who took an oath to do first, do no harm. I felt betrayed by my government, my country. I lost my job because of this. All the seniority I had at the airline I was flying for at the time, I lost all that.
Had you had any history of things like this that might lead somebody to reason to believe you would harm a child?
No.
Did you believe once you first realized that because of this, the child abuse pediatrician that for whatever reason was interacting with your daughter, and you became aware at some point that they were zeroing in on you, did you believe that as an American citizen you would be charged of a crime like this?
No.
You did not believe it?
I didn't. I was naive to it. When this first all happened, I thought, well, we just need to cooperate and straighten out a big misunderstanding. And then as we got into it further and further, I actually asked the child abuse pediatrician, do I need an attorney? And I can tell you something very egregious about these child abuse pediatricians. They don't treat children. They investigate. They do investigative interviews and contact investigative agencies, child protective services, police departments. They don't actually treat children. In fact, the child abuse pediatrician who I came into contact with has a federal grant to diagnose abusive head trauma, which is shaken baby syndrome. It's the new word they use.
Yeah, they can't call it shaken baby syndrome.
can't.
Why can't they call it shaken baby syndrome?
Because that science has been defeated.
Yeah. Could that explain why the Office of the Attorney General refuses to refer to Mr. Roberson's case any longer as a shaken baby case?
Absolutely.
You were shocked to learn you were charged. Did you ever believe, as an upstanding citizen who loved their daughter, and to be very clear to everybody, the government, no government at any point, at any level, is maintaining the accusation that you harmed your daughter. Is that correct?
Correct.
Okay, so this is not my opinion up here. This is the official position of governments at all levels in the state of Michigan. How shocked were you when you went through the trial and found yourself convicted of a crime you didn't commit?
It was very shocking, very tough to describe, especially as I awaited sentencing. They were still harassing my family. My wife and daughter had to leave the state of Michigan because they were still, CPS was still trying to enter the home and, see my wife and daughter. So it was a horrible time. I was awaiting sentencing, not knowing I was facing 10 years. Having to have conversations with my wife like, hey, you've got the baby, you've got our baby girl, whatever you got to do. I might be going away for a long time. You might need to just divorce me and get me out of your life, because I went into jail still facing a parental rights hearing. They still were full speed ahead trying to, terminate my parental rights. I had a parental rights hearing for termination while I was incarcerated.
And you were in prison for a total of a year. You got
Yes.
convicted, sentenced for a year. It's hard to imagine, it's hard for me to ask the question, but how would you extrapolate that if somebody was in your situation but was convicted of the same crime, the same theory, shaken baby hypothesis, but ended up spending over 20 years in almost exclusively solitary confinement? What would you say to that individual? What would you say to people listening to you right now, contemplating, grappling with that type of reality?
I would say what you said first. I would say I'm so sorry that this has happened to them, but don't give up the fight.
So I want to pick up on that because as I discuss this case with people, not just across Texas, but all across the country who are shocked when they start digging into this, I hear people say, when they're really perplexed by the actions that have been taken up here. And I've tried to make the point that, like our founders, they spent a lot of time on the rights of the accused in the Bill of Rights. Just go read the Bill of Rights. That was very important to them. One thing that I've heard repeatedly is that these are, maybe somebody didn't commit murder, but if you're on death row, if you're convicted of murder, at a bare minimum, you're a horrible person, and this type of thing could never happen to me. So why should I concern myself with it? What would you say to somebody who disagrees vehemently with the actions of this committee? And one of the reasons is they believe they are upstanding citizens, they don't have rap sheets, and that the government could never falsely convict them of any crime. So what consequence is it to them? What would you say to somebody who says things like that?
It happened to me, and it can happen to anyone. It can happen to anyone. I was an airline pilot who went through FBI background checks every year to make sure I wouldn't crash an airplane into a building, right? After 9/11, fingerprints on file with the FBI. The most stringent criminal record searches every year done on me, and it happened to me.
Had you had any criminal record whatsoever prior to this?
No.
Never been arrested for anything?
Back when I was a teenager.
Okay.
Yeah.
But I am very familiar with FAA regulations.
Yes.
And the strenuous security, especially in a heightened post 9/11 environment that airlines and airline pilots are subjected to. One thing real quick, you've mentioned some of the similarities and differences. You followed the Roberson case at least a little bit, is that
Yes,
correct?
as much as possible.
Right. Some of the things you mentioned, that it appears, similar in comparing and contrasting this, it appears you had the public largely behind you.
I did.
That has not been the case in Mr. Roberson's case. I would assume, are a respected member of your community, a professional, an airline pilot, somebody who literally has hundreds of lives placed in the palm of your hand on a daily basis. You're educated. You had means. I just heard it in your testimony. You had money. Talk about the potential differences in the system, somebody who is a marginalized citizen, a ninth grade education, somebody who's autistic, and somebody who had no connections to any political or elected officials and no connections to resources to help them in a defense. How do you think you're sitting here today and somebody in that type of situation, not necessarily him, but somebody like him, how could you see a justice system that's supposed to be blind, Lady Liberty's supposed to be blind, how could you see the potential disparities for somebody like you, accused of shaken baby syndrome, and somebody like him?
Yes. Well, I think it's a disaster from the start for him because he's not allowed, if he has a public defender, what's the budget for expert testimony and expert witnesses for a person in the public defender's office? I mean, right there.
Well, actually, let me ask you that, because one of the facts
Yeah.
one of the early facts I learned about this case that I found most troubling was when I learned that his court-appointed public defender agreed from the outset with the prosecution's theory of the case, and he said, and this is a direct quote, the court-appointed public defender said, and I quote, "This is a classic shaken baby case." How do you respond knowing that? How should people respond knowing that?
It's egregious. It's
Could he possibly have had a fair trial if that was the position of his own attorney?
absolutely not.
Why not? Why
Should have
not?
been a mistrial for saying that alone. Because that's just, that coming in with that bias, how can he get a proper defense under our Constitution.
Talk about that, because you were accused of shaken baby syndrome. You had
Yeah.
you mounted a defense.
Yep.
His attorney said this is a classic shaken baby case. So if that's true, that the defense attorney agrees with the prosecution's theory of the case, for people who don't understand the triad and the intricacies of shaken baby and what constitutes it, for people watching maybe at home, why is it impossible, and this is the position of our committee, why is it impossible for him to have had a fair trial?
Because any doctor that testified in his case was testifying against him, and there was no rebuttal witnesses. Yeah,
So because his attorney agreed with the prosecution's case,
Yeah.
no jury ever heard or interacted with arguments or evidence of potential innocence. Is
Correct.
that correct?
correct.
Okay. Thank you. And I want to move on here to let other people talk. But one thing that I do think is really important. You're here, and you said in your testimony, if I heard you, so tell me if I'm correct, you said you are here to speak for Mr. Roberson. Is that what you said?
I am.
Okay. What do you say to people who would say to you the things that they have said to every person sitting on this dais, that you are here to protect a baby murderer, that you are soft on crime, that we are engaged in government overreach? Are you here to protect a baby murderer, and are you soft on crime?
Neither, no. But what I am here for is encouraging our government and all people to follow evidence-based science. And I'm here to say that there is enough reasonable doubt in his case, there is enough questions in his case, that we got to hit the pause button. There's a man's life hanging in the balance. What harm is it to say, pause? Let's stop this execution and let's have some evidentiary hearings. Let's look at the new science-based evidence and see if maybe we got some things wrong here. What's the harm in that?
It sounds like you're advocating that he should receive a new trial.
Absolutely.
You're not advocating it, but tell me if I'm wrong. You're not advocating they simply, TDCJ just opens the door and let's walk out tomorrow.
No.
Is that correct?
Correct.
You're advocating that he receive a new
A
trial.
new trial
With all the evidence.
with all the
For
evidence.
the first time in 21 years.
Absolutely.
And then my final question would just be, maybe you directed some of your comments to some of my colleagues in the executive branch. What would you say to any constitutional officer of the state of Texas who has any power to exert any control over what happens next in the case of Mr. Roberson? What would you say to them?
I would say, be humble. Follow the evidence. Follow the science-based evidence. Put your pride aside. Put aside the fact that you want Texas to have the reputation of the tough on crime. We get it. Put your politics aside. This is a man's life.
Be humble and seek justice. Is that what I heard from you right there?
Absolutely.
Thank you so much for being here today, and I'm again so sorry for what you and your family were subjected to at the hands of your government.
Thank you, Mr. Harrison.
Thank you, Chairman.
Thank you, Mr. Harrison. Members, do we have other questions for Mr. Burns? Yes, Chairman Darby.
Thank you, Mr. Burns, for being here. Your story is powerful, and I hope it's compelling. I'd like to drill down, if you will, about your trial, because the time frame that we're dealing with, this crime, quote unquote, occurred back in 2002, 2003. Your trial evidently happened in around 2012, 13?
2015.
15, okay. In 2013, the legislature determined that science does change its view. And we passed a law in 2013 giving an avenue for an accused to appeal to the Court of Appeals, in this case, their conviction based upon junk science. And we set up a procedure and a series of findings that need to be made in order for that to happen. So in 2013, it was fairly well established, I think, in this state, and I want to get your reaction, and in Michigan, that junk science that we're referring to was not only the DNA ways to analyze who perpetrated the crime, but also the shaken baby hypothesis that you've been referring to. So in 2013, this legislature recognized that science had changed, but yet after that, your case occurred in 2015, and yet you were convicted on a shaken baby hypothesis. So kind of walk through that with us, because one of our challenge here, or a future committee in the legislature is going to be tasked with finding out, is this statute that we passed in 13 and amended in 2015, did it go far enough, or was it clear enough? Did it give enough direction to the Court of Appeals to establish a real habeas procedure based upon changing scientific evidence?
Mm-hmm.
And so I'm curious to know, at a time and an era that, at least in Texas, we were recognizing that this hypothesis was no longer valid. Michigan charges you in 2015. So tell me, under what theory were you persecuted or tried for this crime and convicted of this crime?
So, Mr. Darby, by then, they weren't calling it shaken baby syndrome anymore. They called it abusive head trauma. They just changed their terms. So the doctor who accused me said that, well, no neck injuries are needed. The subdural hematomas and retinal hemorrhages are enough. But the biomechanical science has proven that to shake a baby, the force required to shake a baby, there are always neck injuries. There was a study done with crash test infant dummies where they had these huge college football players come in and shake the dummies as hard as they could. All of them had fractures. All of them. But we've got the other side here, the Child Abuse Pediatrician Committee saying, oh no, this could happen from throwing a baby into a soft surface. And then they'll say right out of the other side of their mouth is, oh no, a short fall couldn't cause these injuries. It's just talking in circles. None of it makes any sense. It defies logic.
Well, clearly you were tried under alternatively named hypothesis on what caused your infant daughter's injuries. And then followed on through to the Michigan Attorney General and the Innocence Project there, ultimately getting you exonerated. Was there a change in view on that abusive head trauma?
It is
Injury that gave those officials pause for concern that would indicate that you were indeed innocent and thereby should be exonerated from that crime?
These cases are slowly collapsing as people look at evidence-based science. The Attorney General's office looked at 8 expert reports that were written when they reviewed my daughter Naomi's records. All 8 reports were saying this was from birth trauma. So all of that was taken into consideration. There was also, when we came face to face with this child abuse pediatrician, we demanded a second opinion, that she get a second opinion. She reached out to a leading retinal eye expert in Philadelphia, and my daughter had a condition called thrombocytosis, and there was an email chain that we got through discovery that this pediatrician tried to cover up, that revealed that with my daughter's thrombocytosis, it threw all the retinal images into question for shaken baby syndrome or abusive head trauma.
Okay. Yeah. So this evolving science, in the end, was able to exonerate you from the charge?
Yes.
Going back to Representative Harrison's question, the original trial, I didn't make this count, but a witness that testified before us said that shaken babies syndrome was mentioned over 45 times in the trial. Now, they didn't mention it in your case. They mentioned abusive head trauma. But from your perspective, having endured all of that process, if the prosecution and perhaps or the defense counsel had mentioned the word shaken baby syndrome, the mere name, being charged with that indicates guilt to me. If you're charged with shaken baby syndrome, it means to me that somebody shook that baby and you were the last person to have that baby, so you're the likely perpetrator.
The prosecutor said in my case, something happened to this baby, so you must convict. Something happened? A traumatic birth happened.
Okay. Thank you for your testimony. It's very compelling. You've taken time out of your life and your family's life to come down and share that with us. It is powerful testimony.
Thank you, Mr.
And I
Darby.
think it's compelling on this committee and those who may follow this committee that we try to get it right. I value all of my colleagues' comments today. You can tell that there's been a lot of focus on why we're here today. And, but I for one will say that nobody should ever challenge this committee's willingness to find and do what's right with regard to not only Mr. Robertson's case, but for every other Texan that may come under the heavy weight of laws that this legislature may pass. So thank you for coming and being a part of that today. It
Thank
means
you,
something.
Mr. Darby.
Thank you. Yeah, I think I find it interesting. I remember when we would pick jurors in trial, it makes me think about this exchange is the attorney would ask the jury pool, how many of y'all can tell me that you're never going to commit a crime? You're never going to commit a crime. Oh, of course, everybody's hand up. I'm never going to do that. Absolutely, I'm law abiding. Okay, everybody hold your hand up if you can promise me that you'll never be accused of a crime. So just understand, that is, and Mr. Harrison references, that is why the founders spent an enormous amount of time on the rights of the accused. It's why a committee like this is integral to ensuring that our society has a just and fair system. Like this is the work we get to do. And for far too long, people, I think, Brian, you said this very well, people have kind of given this area a pass. We don't have to be skeptical here, but it's okay. And you get better results when you ask the questions. So I appreciate you being here. I don't know, do we have any other questions for Mr. Burns? I didn't want to, yeah, oh, yes, sir. Mm-hmm.
Thanks, sir. Just one clarifying thing to pick up something you said to Representative Darby during his exchange with you that I think is so important. And you sort of, as somebody who is, for better or for worse, you have lived with shaken baby syndrome / abusive head trauma for years. And when I heard you say it, I know the import was apparent to you, but I fear you might have glossed over it so quickly when you said it. And that deals with the vernacular. Okay, you were charged under abusive head trauma. Mr. Roberson, prior to that, was charged with shaken baby syndrome. And one of the chief criticisms of the work of this committee, and basically everybody involved in trying to say, hang on, the court system messed up here and got it wrong, is when we say he was convicted under shaken baby syndrome, one of the most frequent retorts we hear is that no, it wasn't a shaken baby case. And by the way, this is the official position of the Attorney General's office today, who put, and I'm going to try to quote from memory, but I'm really close, only off by a word or two at most. Their official position now is that a jury convicted Mr. Roberson of, quote, beating his child to death. That is the official position of the Attorney General, so the state of Texas right now. But the semantics matter here, words matter, and they confuse people. Because when this committee is asserting that Mr. Roberson was convicted 20 years ago, 21, 22 years ago, of shaken baby syndrome, they point reflexively to the medical examiner, because in the medical examiner's documents, she made reference to head trauma. And I want you to help people who are watching understand how that is, in fact, not different from shaken baby syndrome. Because when I first heard head trauma, I think like everybody else, I had the image of a head, a healthy, functioning head, and some object, and then some object external to the head, and then some force, an external object made impact with the exterior of the head. And I think that's what everybody hears, myself included, when I first looked at this. When you hear the child, on the medical examiner's report, it references head trauma. Can you please talk as if you're talking to people who haven't lived and breathed this, but you glossed over it in your exchange with Mr. Representative Darby when you said head trauma versus shaken baby syndrome? Because people say, no, it's not shaken baby case in Roberson, it was a head trauma case. Help demystify and clarify some of that up, if you don't mind.
Sure. So for years, they called it shaken baby syndrome. And as the science-based evidence and research and biomechanical engineers and the leading doctors, neurologists, everybody involved in this took an honest look at the science-based evidence, the shaken baby syndrome community realized that they had to change up their terms because they were being defeated. So they said, we're now going to call this abusive head trauma. It's no longer shaken baby syndrome. We'll call it abusive head trauma.
And is it true in those cases, because I think this is the central point, is it true, based on your knowledge of this, that the head trauma does not necessarily, and in fact, in the case of shaken baby, it's explicitly like preclusive, it's not necessarily that something outside of the head made impact with the head?
Correct.
So you could have a medical examiner's report say head trauma, but that medical examiner know full well nothing outside of the body hit the head.
That's correct.
You can see how this is confusing for people.
Very much.
Thank you for helping us clarify that. Thanks, Chair.
Thank you very much. Mr. Leach, did you have any questions or? Okay, any other questions for Mr. Burns before I excuse him? Mr. Burns, thank you so much for sharing your time. You mentioned celebrating Christmas and that you're a Christian family, so I want to wish you a Merry Christmas.
Merry Christmas to all of you.
And you also talked about what message you would have to someone that was sitting in that cell. You said not to give up. Right?
Not to give up, no.
Christmas is a season of hope. And when we sat with Robert on death row, we prayed Romans chapter 5, verse 1 through 5. And I won't recite it here today, but I would encourage everyone to go look at it.
Thank you.
Look at it and think about hope and hold it in your heart. Thank you for being here, Mr. Burns.
Thank you. Thank you, committee.
Yes. We do not, hold on one second. Apologies. I'm trying to navigating a space in which a state agency doesn't comply with the government code creates a few complications. And so wanted to just make sure this is the time that I would call Mr. Roberson. He was duly served, legally served. Obviously, he wasn't able to register, and so this is when I would have called him to testify, but I don't have a registration for him because he was prevented from being here. Mr. Leach.
Thank you, Chairman. Before we adjourn, I want to ask a couple questions for the record. I believe strongly, especially after hearing what we've heard today and understanding where we are procedurally and what the Attorney General's office is doing and the position that they're taking. I feel strongly that, members, we have not come this far to only come this far. And we owe it to Mr. Roberson, to the people of Texas, and we owe it to our fellow House members as we head into a new legislative session to get answers to some of these lingering questions as to what the Attorney General's office can and cannot do when it comes to interfering with the legislative branch's constitutional authorities. And so, Mr. Chairman, I would like to suggest, in fact, I feel strongly, that the Attorney General himself and/or his designee should come in front of our committee between now and January 14th and answer questions. Not in a letter writing campaign, not in an email campaign, but in front of our committee and in front of the whole House and in front of the people of Texas. One of the questions that I would like to get answered sooner than later is, if I drive to the Polunsky unit and want to meet individually with Mr. Roberson, can I do so? It has always been the case that legislators can, and many of us have, visited units and been granted full access to incarcerated individuals, including those on death row. And TDCJ, to their great credit, has always welcomed and rolled out the red carpet to legislators who want to do so. I know I've done so on many occasions, and I know you have as well. So if tomorrow or Sunday or Monday, if I show up myself or if a group of members on this committee or otherwise showed up at the unit to meet with Mr. Roberson, is the Attorney General's office telling us that we cannot do so? I'd like an answer to that question. I would also like to suggest, Mr. Chairman, I will defer to you and your able leadership of this committee, but I would like to suggest that we schedule a hearing in early January before January 14th and invite the Attorney General's office, not only invite, but demand that the Attorney General himself and/or his designee appear in front of our committee. I think it's entirely reasonable. This committee has jurisdiction over TDCJ, and we are being told, Mr. Chair, as you've appropriately noted and we've referenced many times today, that we cannot communicate with the state agency. So I would like to suggest that we consider reconvening in early January and inviting the Attorney General's office to testify. I think we owe it, as I've mentioned, not only to Mr. Roberson and to this committee, but also to the entire Texas House to get those answers clarified before we head into next session. And he can even do so remotely. He doesn't have to come here to the Capitol. The Attorney General I've seen appear on Fox News from all over the world. So if he can appear on Fox News from overseas, then he can appear in front of this committee from overseas as well. And I think that this committee will be eager to reconvene to achieve those purposes. And I would just like to officially make that recommendation and request.
I noted, and I will communicate with you offline to discuss that further. Members want to make sure that y'all don't have anything else to offer at this time. I do want to be clear, because I think the comments about not communicating with TDCJ certainly have been pointed in the direction of myself and Representative Leach. With the kind of not so veiled threat that we are attorneys and we are communicating with a represented person, the DDCJ, an entity. Except, and I would encourage people to actually read the rules of professional conduct, I am not an attorney representing a client. I am a member of the legislature trying to do my job with a state agency. So the threats need to end and the cooperation needs to begin. That is how we do our job. It is what the people of Texas expect us to do. I have nothing further on this agenda today, members. I do want you to know that I intend to leave the committee at ease, and I'll visit with you all individually to discuss that. The time is now 1:22 p.m. and the Committee on Criminal Jurisprudence stands at ease.